Good evening, everyone. My name is Hajra Hassan, and I'm a certified financial planner and senior advisor with TMFD Financial. I'd like to start off by thanking you for joining us this evening, and in a moment, I'll introduce our presenter, Meghan. First, I'd like to briefly introduce TMFD Financial and explain the valuable services we provide to our clients. Our goal is to make the financial lives of our dentists simpler by combining a variety of services under one roof. From tax, investments, insurance, and other financial planning matters you may have. Additionally, we coordinate with other professionals that you may need, such as lawyers, mortgage brokers, bankers, in order to make sure that your current and future needs are serviced. In our experience, we found that providing these resources as a one-stop shop, it gives you the comfort of knowing that all your aspects of financial well-being are synchronized, and the result is simplicity, peace of mind, and confidence in your decisions. In addition, TMFD Academy hosts webinars like this one to help enhance both your clinical knowledge as well as wealth management. At this point, I'd like to hand things over to my colleague, Aaron Carvello, and he's just going to go over a few housekeeping items.
Thank you, Hajra. So for those unfamiliar with Zoom webinars, if you have any questions for Meghan or Hajra, please utilize the Q&A button found at the bottom of the screen or device that you're currently using, and we will get to them at the end of the session. Alternatively, you can raise your hand if you would like to be called upon. Lastly, there is a chat button as well, which allows you to communicate with anybody attending this webinar. In regard to CE credits, these will be sent out within the next 2 weeks. Back to you, Hajra.
Thanks, Aaron. I'm pleased to introduce our speaker this evening, Meghan O'Neill. Meghan joined Mills & Mills LLP in 2016 and became a partner in 2022. Since her call to the Ontario Bar in 2015, Meghan has focused her legal practice in estate law, particularly in areas of estate planning and administration. Meghan holds a trust and estate practitioner's designation from the Society of Trust and Estate Practitioners, of which she's a member. She's also a member of the Estate Planning Council of Toronto. Meghan frequently presents on the topic of estate planning and administration to financial institutions, community groups, professional development programs for many associations. Over to you, Meghan.
Thanks so much. Thanks for having me. I'm really happy to be here. The plan is for me to talk for about an hour about estate planning matters, and we'll definitely leave some time for questions from everyone at the end. We'll also have a few questions interspersed throughout my presentation that will take some polls from everyone here to get a sense of what people's understanding of these things are in advance, and then we can talk about those in more detail. But it will be interesting for all of us to get an idea of what people's expectations are as to what some of the answers of these questions are in advance. So I have quite a bit of material that I'd like to get through. So I'll go ahead and get started. I'm going to share my screen here. Okay. Just bear with me as I get everything here pulled up. Okay, and first things first, let me see if it will let me click as I'm intending here. Here we go. I should always have to mention at the very beginning that it's not legal advice. It's just general information. How these principles will apply to any given individual really will depend on your circumstances, and is something you really should speak to a lawyer about to understand how it may apply to you against the facts of your particular circumstances. But all to say, we're speaking in kind of broad strokes about things that everyone should at least have a beginner's kind of knowledge of some of the big picture items, so that they know what it is that maybe they need to go speak to their lawyer about in more detail. So just to give you an overview of what we'll be covering today, we'll discuss why you need an estate plan. We're going to discuss probate tax planning, estate planning traps, as I've called them, things that are just common misconceptions, I guess we can say, about estate planning that I hear quite often, that I find that I'm correcting a lot of people on, and some trust basics. We won't get too far into the weeds on trust because that is quite complex and a bit outside the scope of what we're trying to cover today, but I do want to cover at least the basics of those two. So why you need an estate plan? A number of reasons. I'll try to sum up some of the important ones here. So you want to have, as you'll see, these first 3 bullets, all of them have to do with control. If you don't have an estate plan, you don't get to control who is acting as your executor, being the executor and trustee, formal names estate trustee of your estate, who's administering your estate, who's making sure that it gets administered as set out, or as you want, really. Otherwise, we have to default to legislation to see how things are distributed, and also who is even able to do that, because there's a priority of who is entitled to make that application to be that person if you don't appoint that person in your will. We'll talk about what that hierarchy looks like a little bit later. Attorneys, when I use that word here, I mean an attorney for property or an attorney for personal care. So I'm not talking about an attorney like a lawyer. In this context, it means your substitute decision maker. It's the person who you've named to make decisions on your behalf in the event that you are incapable. And you would name an attorney for property to make decisions with respect to your assets, as well as an attorney for personal care to make decisions with respect to your care. So we'll talk a lot more about those a little bit later, but it's really important that you have control over who those individuals are who are making decisions with respect to your estate upon your death, and with respect to the management of your assets and your care in the event that you're still alive, but you're incapable. You want control over naming the beneficiaries of your estate. That, in other words, the beneficiaries are the people who are going to benefit from your estate upon your death. Who you want to benefit and how you want them to benefit, in which proportions, needs to be set out in your will. If it's not, then it's going to be the legislation, the law called the Succession Law Reform Act, that will govern how everything is split up. So that's not going to reflect what everyone actually wants, what is set out in this piece of legislation. As you can imagine, this is not cookie cutter. It's not a one size fits all, but if you don't have a will, then you're stuck with the cookie cutter approach that is in the legislation, which we're going to talk about more what that cookie cutter version looks like. And then controlling terms on which the beneficiaries actually receive their inheritances. In a lot of cases, you're not going to want a beneficiary to actually receive their interest in your estate outright, and rather there may be a need for a trust. That could be because you have children under a certain age, or because you have a loved one with a disability, they're receiving ODSP, and you don't want to make them ineligible for the government benefits that they're receiving by them coming into a huge lump sum of money from your estate. So those are just a couple of examples, and when we're not going to want people receiving money outright. And if you don't have a will, you don't get to set up any terms around that, which can be really problematic. And I see the problems that arise from that on the administration side quite often, unfortunately. Saving administration costs. The long and short of this is that it will always cost less to do the proper planning on the planning side of things than to deal with a poor plan or a lack of plan altogether on the administration side of things, which is the estate administration. Once someone has passed, the cost of dealing with that, which can include litigation, because where people don't plan properly, it's that much more likely that people are going to end up fighting over what should have been done or what the deceased would have wanted to happen. If you don't actually put that in black and white in your will and your powers of attorney, and then when you're gone or you're incapable, you're not there to actually speak for yourself as to what your intentions were. And so that leads to other people potentially making competing claims about what those intentions were. And in that event, that oftentimes will lead to litigation, which is extremely expensive and extremely time consuming. It can take years for litigation, estate litigation, to get settled. We see that at our firm all the time as well. And so it's always, no matter what fee quote you get to get your wills and powers of attorney done, it's going to be far outweighed on the other side of things than just investing in doing a proper plan. The probate tax savings, the income tax savings, there's so many missed opportunities where you don't have a will in place. You really want to talk to your lawyer about all these different strategies, some of which we're going to touch on today. But again, you need to know what those are specific to your circumstances. If you don't have a will in place at all, that's a lot of missed opportunity in terms of both income tax and probate tax savings. And I already touched on this in my earlier point here, that you want to avoid litigation, and a proper estate plan can help you do that. So why you need let's see, do we move to the next one? Yeah, so we're still on the why you need an estate plan section here. And essentially, and I just mentioned this briefly, if you die without a will, that's called dying intestate. If you die with a will, that's testate. The Succession Law Reform Act is a piece of legislation that will govern how your estate is distributed if you do not have a will. And that's that cookie cutter approach you're stuck with that I mentioned. And so I think, Erin, this is a good time for our first question, our first poll, if you can put that up on the screen. So we'll give people a little bit of time to answer this, being true or false. If you die without a will, everything will automatically go to the government. Okay, so everyone answered. Awesome. It looks like everyone answered. Okay, so we have 87% false, 13% true. So the answer is, in fact, false. If you die without a will, it doesn't mean everything will automatically go to the government. However, again, it may not be the distribution scheme that you actually want. So, oh, and I'm not sure if I get to, Erin, do I share these results here so everyone can see, or can you do that?
Yep, I shared it, and then
Okay.
I did.
Awesome. Okay.
Oh yeah, perfect.
Great. All right. Good to know. So I'll end this poll then. And so what the legislation sets out as to how your estate will be distributed, there's a whole table basically that, based on your facts, that your facts will get plopped into the table and will determine how your estate gets distributed if you don't have a will. You would basically have to have no living relatives in order for your estate to go to the government. There are situations that we see where I had someone reach out to me recently where there was a small life insurance policy, and that was payable to the estate because the person had not named beneficiaries on the policy. It went into the estate, but the estate didn't really have anything else by way of assets. So this policy was not worth much. It was maybe $7,000, but because the cost of actually getting probate for this estate without a will, and the paying the probate tax on it and whatnot, all things considered, actually with that one there, we wouldn't have had to worry about that given the value, but all to say, all things considered, there was no point in this person getting probate to get this $7,000 life insurance policy that ended up going to the estate simply because that person hadn't named a beneficiary. And in that event, that $7,000 eventually is going to go to the Bank of Canada, not because there's no one living to claim it, but because the costs of claiming it are not even worth the value of the policy. So we'll talk a little bit more about beneficiary designations, but I mentioned that only because that's an example where even in that case, it's an example where because of poor planning, eventually that money will go to the government because there's not a way to claim it. And so, or rather, as I said, not so much that there's not a way, but rather the cost benefit analysis there just doesn't make sense for that person to do the whole entire process of applying for probate and the costs involved with doing that, which we're going to talk more about. It's not worth it for them to then get a $7,000 payout. Those will outweigh it. So in that case, eventually those funds will end up having to go to Bank of Canada because no one's going to claim it, no one who has the right to. But generally speaking, it would, in terms of how your estate would be distributed, it would have to be essentially no family members living to get there. And so I'm going to show you the next slide that has that table on it. And this is, as you'll see, there's quite a bit here, but the different facts of each scenario. So if you have a spouse and you have no children, everything's just going to go to your spouse. If you have a spouse and one child, your spouse is going to get what's called the preferential share. For anyone who dies after March 1st, 2021, when the rules change, their preferential share is going to be the first $350,000 of the estate. So it's going to be $350,000 after debts and taxes are paid, $350,000 off the top to the spouse. And then depending on how many kids you have, it's going to determine how much of the remainder goes to the spouse versus the other kids. Because if you have only one child, then it's going to go after the preferential share is paid to the spouse, then half is going to go to the spouse, half is going to go to the child. If there's more than one child, the spouse is still going to get their preferential share, but then it's going to be 1/3 to the spouse and 2/3 to the remaining children. If there's no spouse, it all goes to the kids. If no spouse or children or any more remote issue, which means your lineal descendants like grandchildren, great-grandchildren, so on and so forth down the line, then we go back up to family members, other family members. So it's parents, if any are living. If there's no parents, then we're looking at siblings. If there's no siblings, we're going down to nieces and nephews. If no nieces or nephews, then no next of kins, which can be like cousins, everything, then we are going to the crown. But as you see, it's a lot of people that would not have to be there for it to actually default to the government. So these defaults oftentimes do not reflect people's intentions. So for a lot of people, they want their entire estate to go to their spouse in the first instance. If they're married, at least in most first marriages. In contrast, in a second marriage situation, they may not want everything to go to their spouse. A lot of couples who are on their second or third marriage, as the case may be, or whatever the case may be, in any event, if they're married to someone who is not also the person that they have their kids with, then they may not want all of their estate to go to that spouse. And rather, each of them may have said, we're keeping everything really separate. Both of us are leaving to our respective children. And we've arranged this for each other in terms of the plan. But if they don't have a will, everything's going to go to their spouse, regardless of whether they have children they don't have a will. That preferential share is going to go to their spouse. And then a huge chunk of the remainder is also going to go to that spouse. Despite the fact that they have children from a first marriage that they may actually want to receive the majority of their estate. So the blended family situation that I'm mentioning here is also really important, that reflects people's intentions, because where there may be, say, a spouse and children, sometimes those estate plans may be simpler, because it may be, I just want everything to go to my spouse, and on the second of us to pass, everything goes to our kids. But not every approach is going to be that simple, and blended families are one of those examples where people have other types of strategies that they want to employ, and estate plans that they want to put in place, taking into account the different factors of their situation. And if they don't have a will, they don't have control over making sure that's put in place the way that they want to. Also, there's no defaults in the SLRA, the legislation that sets out that table that you just saw, that, for example, puts trust provisions in place, or a guardianship clause. A guardianship clause is what you include where you have minor children under the age of 18. You want to be able to control and say in your will who you want to act as guardian of your children in the event that both parents die while your children are still minors. You want to make sure you have not only someone named, but also an alternate named in the event the first person cannot act. If you don't, then that can lead to competing claims among family members who may think that they are in the best position to act. And if there's more than one person who thinks that they should be the guardian, that can create a lot of conflict and potentially, again, more costs that could arise from litigation. And so it's important that you put in your will, where you have minor children, exactly who you would want to act as guardian of those children. It's just a temporary appointment. They still have to make it official with the court, because the court is always going to consider what's in the best interest of the children. And who you name in your will as a guardian, if for some reason something changed between the time you did your will and the time that you died, and that person no longer was someone who was really fit to be a guardian, then the court would have control over saying, well, what's in the best interest of the children. But the court is always going to give huge deference to whatever a parent has set out in their will in terms of who they want to act as guardian of their children. Very important that you have a will to state that. There's no default for that in the legislation. And if you don't have a will, any minor children, they're going to be entitled to their interest in your estate as of age 18. So any kids will be entitled to their inheritance at age 18, and the whole thing, which is very young. Most people would agree. And in a will, you have the ability to set out, I want my kids to receive maybe 1/3 at 21, 1/3 at 25, the balance at 30. There's going to be a number of factors based on your circumstances, the ages of your children, your net worth, and just what the amount of that inheritance could look like, the number of children you have, all these factors that are going to inform what those trust provisions may look like for you. But you're always going to make sure, or want to make sure, that you have those trust provisions in place. Otherwise, that payout they're entitled to at age 18 to do whatever they want with that money. And until they're 18, during that time, there's nothing saying, okay, so how is it managed in the meantime? And so that is extremely problematic too, because whenever you have funds held in trust for a child or another beneficiary who requires a trust, you want to make sure those trust terms are very clear and give the trustees the flexibility that they need in order to manage that trust in the most effective way for those beneficiaries. And so you want that set out right in the document, the will, rather than that having, essentially that money having to be paid into the court, and who's ever appointed your executor, or technically administrator, they're called, where there is no will, then having to deal with the court with respect to payment of those funds. And also they would have to deal with the Office of the Children's Lawyer, which is a office within the Ministry of the Attorney General. So they're dealing with the government, they're dealing with the court over how to actually access these funds for the benefit of your kids, because there's no trust terms giving them the access to those funds that they need to manage those funds for your children's benefit. And children are just one example. As I mentioned briefly earlier, you're also going to want trust in place if there's any beneficiaries with any disability. They're going to need the proper trust planning in place to make sure that, again, the trustee can manage those funds in a way that is most beneficial for them, but also that those funds don't put them offside from qualifying for their ODSP, which anyone who has ODSP hugely depends on that, particularly for costs of medication, for example. It's extremely important for them to maintain their ODSP eligibility. So it's very important that they are not paid a lump sum from an inheritance that's then going to put them offside from being able to receive those government benefits, which they rely very heavily on. Other times we would put what's called a spendthrift trust in place, which may be where there's a beneficiary that maybe has addiction issues, for example, and the client does not want them coming into their full inheritance all at once, because they have concern over how those funds would be used by that beneficiary. And so these are a number of examples where trusts are appropriate, but really necessary, really, and you don't have control over any of that if you don't put those provisions in a will. So very important to have a will for all of those reasons. We'll move on to the next one in the interest of time here. So this just sets out who is able to actually apply to be your executor in the event that you don't have a will naming that person. So it's the first priority is the spouse immediately before death, or a person who the deceased was living in a conjugal relationship with immediately before death, next of kin, or some combination of that. One thing I'll note here, is that you want to consider, when you're choosing an executor, there's a number of factors to consider. Who is set out here may not necessarily be a good executor, regardless of their relationship to you. There's a number of qualities that you're looking for in a good executor, and the defaults are not always going to reflect that. You're also going to want to consider things when you're choosing an executor. For example, someone who is not a U.S. resident, there's a number of challenges that come along with that. And it's important that, I've seen people name U.S. residents in their will, not knowing all of the challenges that come along with that. And so it's very important that you're having that conversation with your lawyer to really consider, okay, who's appropriate to act and who do we really not want to act? For example, U.S. residents, which can be, it's quite common for a lot of people whose kids say maybe move to the U.S. So that's a conversation that needs to happen as well. There's also a missed opportunity here if you have a business where there may be someone who's in a better position to deal with your business in particular than the person who you may want to be dealing with the rest of your estate matters, like your funeral and all of those things that and getting probate. You may have someone in mind who you think would be very good at that, but then there's someone different who would be better suited to deal specifically with your business interests, for example. And so you can name a special trustee, we would call them, to deal with particular assets. And you need a will in order to accomplish that kind of more advanced planning there, like a special trustee. So to summarize, if there isn't a will, basically you're going to be looking at getting what's called a certificate of appointment of estate trustee without a will instead of with a will. It's going to cost more to do that because there's more documentation that needs to be done on the probate side where there is not a will. Where there is no will, there's a lack of assets or lack of access to assets until probate is obtained. So where you have a will, that will gives the executor the authority to actually deal with the assets. There's certain assets that third parties will not release to the executor until they actually have probate. But nonetheless, there will be some assets often that can be accessed in the meantime. There's going to be a complete, not only lack of access to the asset itself, but even to information regarding your assets, which is really, you need information regarding the assets to apply for probate. And the bank, for example, won't even speak to someone. If they come into the bank and say they died without a will, they're going to say, go get probate. I can't talk to you or give you any information until then, because that person has absolutely no authority to get that type of information that they actually need to apply for probate. So that is problematic too. The spouse will not necessarily be entitled to the entire estate, which is what some people's intention is. And again, on the flip side, they may get actually a bigger chunk under the intestacy rules than someone may want their spouse to get in, say, a blended family situation. This is a big misconception that a common law spouse will basically inherit just like a married spouse. Like they're basically treated the same, is this idea. It seems for a lot of different purposes. When it comes to estate planning, that is not the case. Common law spouses do not have the same rights as married spouses. And so it's very important that you have if you have a common law spouse that you want to make sure is provided for, you need to have a will that provides what you want for them, because the intestacy rules, being the rules that govern where there's no will, are not going to help your common law spouse in that situation, because they are not treated the same as married spouses. They do not get the same entitlements as a married spouse. They're not entitled to any type of preferential share, and they're going to end up having to make some form of unjust enrichment or dependence relief claim against your estate. Should they choose to do so, they have no automatic entitlement. So for our purposes, married spouses, common law spouses are not the same thing for estate planning or estate administration. Minor children get their inheritance at age 18. There's no guardianship wishes expressed, and no special provisions for disabled or spendthrift, as I mentioned, beneficiaries. And generally speaking, there's just a lack of control over all the aspects that I mentioned. So next, hopefully that was all convincing enough to inspire everyone to make sure that they have their will in place, and not just a will, but and powers of attorney, but also up-to-date ones too is really important. As circumstances change, these are organic documents that you really want to make sure reflect your current circumstances. So with that, we'll move on to powers of attorney. Again, as I mentioned briefly before, these are documents that govern who can make decisions for you in the event of your incapacity. So they're only effective while you're alive, but incapable. Technically speaking, a power of attorney for property is effective as soon as it's signed, but these are really only intended to be acted upon in the event of your incapacity. When someone dies, their powers of attorney are no longer of any force and effect. And similarly, on the flip side, your will doesn't kick in until death. That document is only authoritative upon death. But during any period of incapacity, while you're alive, the powers of attorney govern who can make decisions on your behalf. They are just as important as the will, and arguably some people would say they're more important, because unlike not having a will where there are those defaults set out in the law, albeit those defaults may not reflect your intentions, the defaults are still there as to how your estate gets distributed and the priority of who's able to apply to actually administer the estate. For powers of attorney, there's no such defaults. And so basically someone's going to have to make if you don't have a power of attorney in place, someone's going to have to make an application to the court to be appointed your guardian for property. And it could be the same person or different people who are applying to be the guardian of personal care. For a power of attorney for property, that person is making basically any decisions with respect to your assets, except they can't make a will, they can't change your beneficiary designations. But other than that, they're really doing everything on behalf of an incapable grantor. They're signing documents on their behalf, paying ongoing taxes and bills, and managing any real property and personal property. They're trying to manage their objective is to manage your assets as closely as possible to how you did when you were capable. And on the care side, that person is making decisions with respect to nutrition, hygiene, refusal or consent to treatment, your living arrangements that are appropriate based on your circumstances, whether you need to go to a nursing home, for example. Things like that are in the authority, if you will, the attorney for personal care. And so if you don't have anyone to do these things for you, there's going to be a period of time, and it can be a significant delay where no one has the authorities to make that decision on, or any of those decisions on your behalf. And that can be hugely problematic because everything is essentially frozen. And even though with the power of attorney for personal care, there are defaults set out in the Healthcare Consent Act in emergency situations who doctors can take instructions from, you're still going to want to make sure that you have control over who that person is rather than having to default to that legislation. And that's not going to apply. That doesn't help on an ongoing basis. If this period of incapacity does last, you're going to want to make sure that you have those attorneys named, because at some point someone would have to apply to be the guardian of personal care as well. And so in addition to this delay where there's no one who has the ability to make these decisions for you, there's also going to be increased costs of someone having to make a guardianship application versus you just having these documents in place saying exactly who you want to make these decisions for you. Again, as I mentioned, a special trustee for your estate in the event upon your death. For powers of attorney, you can also name a specific power of attorney or attorney, they're called in this context. You can name someone specific to deal with your business interests in the event of your incapacity, and have a limited power of attorney that deals specifically with your business and say, I want this person to deal with all my other assets in my power of attorney for property, but this is the person who should be in charge of managing my business assets. And so that's another missed opportunity where you don't plan in advance. So the takeaways regarding the importance of the will, the powers of attorney, again, control. I've mentioned it every time, the trustees, the beneficiaries, the attorneys, you want to make sure you have the say over that, of all of those decisions. To set out wishes for matters where the defaults in the legislation do not reflect your wishes. And again, much cheaper having the plan in place correctly than trying to deal with the aftermath of not having the plan in place for all the reasons that I mentioned. Okay, so at this time, I think it's a good time to do another poll. I'll let Erin throw that up there. So this one is, who may have a claim against your estate? Your spouse, parents, child, sibling, creditors, or all of the above? Okay, so everyone, I think what's in there? Okay. Oh, it's still going. So I think everyone's answered now. All right, great. So the majority got it right. It is all of the above. All of these people could have a claim against your estate. And that would be if they're considered a dependent. And so that brings us to claims by dependents or other creditors. A creditor can be a dependent, but not necessarily. It's the SLRA mentioned here is the legislation I mentioned earlier, and that sets out those defaults. It also says who is a dependent of yours, and you have to consider certain people in your estate plan. If you don't, then they can make a claim against your estate. So that too is very costly when people are basically suing your estate, is what we mean when we say making a claim against it. In that event, that can certainly lead to litigation if it's not settled in advance of that, to actually going to court, that is quite costly to deal with across the board. Whenever I say litigation, just think that's expensive, basically. So all of these people are considered dependents. Spouse, parent, child, brother or sister. A child could include grandchild, to whom the deceased was providing support or under a legal obligation to provide support, even if they weren't technically doing so, immediately before their death. If they have that relationship and the deceased was under an obligation, or was choosing to provide support to that person immediately before their death, then that person can make a claim against the estate, called a dependence relief claim. We always want to avoid claims against the estate. So on the next slide, I get into a little bit more about who can be included in each of these definitions. In this case, as I had mentioned, that there are some claims that a common law spouse can make. This is one of those, a dependence relief claim. But there's a number of factors that go into determining whether or not they will actually receive dependence relief. It's a very long list in the legislation of what the court will look at. And it's not always, it's not easy to determine. It will take into account if there were assets outside of the estate that person received, aside from those that did fall into the estate, such as if they were named as a beneficiary on a policy that traveled outside of the estate, for example, those that will be factored in. But it is a complicated exercise in terms of determining what the dependence relief should be. And that dependence relief may not be what you would actually want it to be for your common law spouse, for example. So it's important that you, in your estate plan, you're properly considering your dependents so that you can try and avoid these types of claims being made. So then we'll move to the next one here. If you are a business owner, whether through a sole proprietorship, partnership, professional corporation, oftentimes there's going to be creditors of the business. Life insurance is oftentimes used as a means of dealing with creditors of a business. You'll have the life insurance policy that's owned by the corporation, and then the person who is the business, or one of the shareholders, as the case may be, they're the life insured, and then the company will be the beneficiary. We're always needing to consider how our debts, taxes, creditors, how are they going to get paid? We don't want to ever be in a situation where an asset needs to be sold that otherwise you would want to have avoided in order to pay off creditors. So we need to think about the structure of the assets, whether there's enough liquidity to actually deal with debts, for example, where I was just talking to a client today where the majority of their net worth was in real property. And that's the case for a lot of people. And so we need to think about, especially in a situation where Maybe they have two properties, again, very common, where they have their principal residence, but they also have a cottage. And yes, the principal residence exemption is going to shelter the gain on their principal residence, but they have a cottage that's going to have a huge deemed disposition and capital gains to be paid on the death of the second spouse, if there's two spouses, or the death of the client, if there's no spouse involved. All to say that deemed disposition is going to happen. And at that time, there's going to be a big tax bill. And we need to think about, okay, what do the assets in your estate look like? And is there going to be enough liquidity to actually pay that debt? Because if there's not, it's going to have to be sold so that the debt can be paid. And for a lot of people, they want to hang on to the cottage. And I won't speak too much about that, because the cottage is really its own beast. But another great example of where you definitely want to make sure the plan is in place, because assets like that tend to have a lot of sentimental value attached to them, is very important for people to plan appropriately for how they want that to be factored into their estate plan. It's something that a lot of families end up fighting over, frankly. And so putting the best plan you can in place, not that you can never conclusively avoid someone from making a claim or fighting, of course, but the better your plan is, the better you can try and mitigate that. So I'm going to, the insolvent estate matters, again, are beyond the scope of the presentation. But again, insolvent meaning where the liabilities outweigh the assets. Always want to avoid that. That's extremely messy. The naming of beneficiaries on life insurance policies and registered plans to ensure they pass outside of your estate. That's one thing to keep in mind with creditor claims, but something we'll talk about in a little bit more detail generally in terms of how that works, whether things fall into or pass outside of the estate. So all to say, it's important to consider who may have claims against your estate, whether it's based on a contract like a shareholders agreement or a marriage contract. A marriage contract is it's the technical name for it here. In the US, they often call it a prenup. But if you have any type of arrangements in place, you need to make sure that your estate plan properly accounts for that, because your estate may have obligations to other shareholders or to your spouse pursuant to the terms of those contracts. And your estate lawyer needs to review those contracts to make sure that the terms of your will don't in any way contradict those, because those contracts, your will should always work as a team. So the takeaways here, it's important to consider who may have a claim against the estate. And again, expensive, time-consuming, and generally messy. And so with that, I think that we can move on to the next pool. So this is another true or false one. Every estate requires probate. Okay. Oh, still going. All right, I think that's everyone. So good. I guess I did a little bit better making this one a little bit harder, because it's a little bit more of a split. So the answer is false. Not every estate requires probate, but that one was a little bit closer, and we'll discuss why that is in a little bit more detail here. So to move on to the probate tax planning, one thing I will just say right off the bat is that you do not want to get too hung up on probate tax. We should save it where we can. And there's lots of strategies for saving probate tax, but you don't ever want this to lead your entire estate plan, because I have seen a number of instances where people get so hung up on the probate tax that they don't consider all the reasons that trying to save the probate tax is now created a number of other issues in their estate plan, which sometimes, quite frankly, are just not worth it. And so it's very important that you're talking to your estate planning lawyer to weigh all of these factors, so that you're not just so hung up on saving probate tax that you then really, in short, mess up another piece of the estate plan by trying to do that. So probate tax is 1.5% on everything over and above the first $50,000 of the estate, assuming your estate has to go for probate. And again, not every estate does. Oftentimes on the first spouse to die, there may not be probate needed at all because a lot of spouses will own their assets jointly. A jointly owned asset with a spouse, not with an adult child, but with a spouse, has the automatic treatment whereby it's called joint with right of survivorship, and it will just pass outside of the estate, bypassing the estate altogether, and go right to the surviving spouse. So where spouses own everything jointly, there's not going to be any need for probate on the first of them to die because everything's going to just pass outside of their estate. The will is what governs the assets that actually fall into the estate. But if they have everything owned joint and they have their spouse named on every registered plan, life insurance policy, they don't need to worry about probate on the first of the spouses to die. If there's anything owned in one spouse's name alone, for the most part, that's going to require probate. So there's some assets that probate's not required on, again, and I've touched on that in the example of the spouse. Assets with a named beneficiary, whether it's a registered plan like an RRSP or RIF, TFSA, life insurance policy, if it has a surviving named beneficiary, it's going to bypass the estate, bypass probate, and thus bypass probate tax. Real estate outside of Ontario is not subject to probate tax here in Ontario, and anything owned jointly with a spouse. We're going to talk a little bit more about other forms of joint ownership in a second. And also assets that fall into what is called a secondary will. So, and some people know this as your personal and your corporate will. Technically, we call it a primary and secondary will. It's the same idea, but there's certain assets that we are allowed to, here in Ontario at least, that we're allowed to siphon off into a secondary will. Some of those big ticket items for most people are shares in a private company and personal effects, which are art, jewelry, furniture, vehicles, any collectibles, things like that, all of that stuff. That is another class of asset that we're allowed to siphon off into the secondary will. Anything that falls into the secondary will and thus is part of the secondary estate is not subject to probate tax. And so this is a huge planning strategy for business owners, is to have a primary will and a secondary will. And the main purpose of that is to save this probate tax. It's a very easy way to save probate tax. And again, a huge missed opportunity for any business owner that doesn't have not only a will, but has two wills. Most business owners are going to want those two wills to save probate tax and the value of their private company shares. So what is probate? Basically, probate is where the court gives their blessing saying, this is the last will of this person who has been provided to us. And there's a number of application materials that the executor who's named in the will, or if there's no will, the administrator has to fill out and provide to the court in order for the court to issue what is called a certificate of appointment, is the formal name, but we still just know it as probate. But that certificate is issued by the court. And once it is issued by the court, third parties like banks, investment companies, the land registry office when it comes to real property, then they will be basically allow the executor to actually access the assets. Technically, the authority of the executor comes from the will, where there is a will. But the reason that a bank will not just release the assets in a bank account to an executor who's named in a will without that certificate of appointment is because if someone comes out of the woodwork later and says, oh, there's actually this other will, and this will revoked the prior will that other person came into the bank and gave you, then now the bank is on the hook because they gave that money out without actually having the court give them the blessing that they could give it out because the certificate of appointment, aka probate, was issued. So that is why probate in practice, that's really why it's needed, is for executors, even though their authority is derived from the will where there is one, they still are not going to be able to access assets in a lot of cases, with some exceptions, until they have that probate from the court that will then allow the third parties to actually release assets to them without them having to worry about that liability of doing so. So probate takes a while to get here in Toronto. Once you actually submit your application to the court, and it takes some time to get that application together. It's a series of materials that oftentimes people get the help of a lawyer to do that for them, because it can get complicated. But you get those materials together, and once you do that, for a lot of executors, that may take a few months at least for them to get that application ready to send to the court. You send it to the court, it can easily take 6 to 8 months for the court to actually issue probate. But again, that application process, usually you're going to get the help of a lawyer or executor well. The estate information return is something that gets filed with the Ministry of Finance after probate is issued, and basically your executor has to give a detailed report of all the assets that you owned at your date of death on which they paid probate tax. They basically have to substantiate how did they get to the amount of probate tax that they paid, and list every single asset that they got to when determining that, because the probate tax is based on what the value of your estate is as of your date of death. And that's what's going to get reported to the Ministry of Finance on this return, and what gets reported to the court when you're applying for probate. They want to know what is the date of death value of the estate. That is what the probate tax is going to have to be paid on. And again, not every asset goes through the estate, because some can go outside of the estate altogether and therefore avoid probate tax if they have a named beneficiary, if they're named jointly with a spouse. So the probate tax planning here that I mentioned already, I won't go into too much more detail about this. I will mention that one other thing that can go into a secondary will is some real property. Typically, real property is going to go into your primary estate. It's going to be subject to probate tax. There's some situations, if you've owned your real property for a number of years, like quite some time, we're talking decades, but if you've lived there for a number of years, there hasn't been dealings with the property during that time, and it's owned in a certain way, which we can confirm when we pull a client's parcel register on their real property. We can look at that parcel register and then say, yep, this actually qualifies for what we call first dealings, whereby it can fall into the secondary estate, the one that does not go through probate, and therefore save probate tax on the value of that real property. It's the exception to the rule, but when you're doing your estate planning, you should very least, if there's any chance that your property should qualify, your lawyer should be looking into that to see whether it does, because there's going to be a huge amount of probate tax saved on the value of real property where it does apply. But again, big thing for business owners to have the primary and secondary wills rather than just the one will. The joint ownership piece here. This I will just mention that, you know what, actually, I'm going to, I think this would be a good time before I get too much into the joint ownership piece to do the next poll. I'll let Aaron put that up. True or false, you should always add a child to the title on your property to save probate tax. And this means that they would be a joint owner, as we mentioned, joint owners, where there's a right of survivorship, that can be a probate tax saving mechanism. But this is with respect to adding a child. And I get this question all the time, people who are coming into me saying, so, you know, I've heard, or my neighbor did this, they added their child to title to their property, easy way to save probate tax. I think we got a few more people answering still. Okay, I think that's everyone. So others had heard this too, apparently, because 21% thought it was true. It is false. You should not always add a child to title on real property to save probate tax. And in fact, there are very few instances where this would be recommended or would work. There's actually what's called presumption of resulting trust, which means that even if you add an adult child to title of your home, it doesn't mean that it's going to automatically save probate tax. You also need other documentation in place to put this plan into place right. And even then, there's a number of pitfalls that come along with adding an adult child to title. of your real property. There is a loss of control over the asset. Now that child is going to have to be signing off on any documentation with respect to your real property, including if you decide you want to put a line of credit or mortgage on it, they need to sign off on everything. So that is one. Another one, a big one, is that now you could lose a portion of the principal residence exemption if your child is not actually living in that property with you and using it as their principal residence. Then they can't, the principal residence technically cannot be claimed on 100% of the value of the property because it's not their principal residence. They can only have one principal residence too. So if they're using the house they actually live in rather than their parents' house as their principal residence, that's going to create a tax issue. You can only have one principal residence in any given year. Another thing is that now that asset is exposed to that adult child's creditors. So if that child has any creditors, which could be, it could be, you know, they get into an accident and that accident is not covered by insurance, and now they have creditors who are making a claim against them. That house that you put them on title to is now one of their assets that's on the line for those creditor claims. And a creditor can also be a ex-spouse or soon to be ex-spouse. If they have a marital breakdown, their spouse may be trying to make a claim to that asset too, of which they own as a joint owner. So that can get incredibly messy as well. So the long and short of this is, do not add your children's name to title of your home or to your bank account without getting legal advice. There's a number of bad consequences, negative consequences that can follow from that. And there's very limited circumstances where this will work. And you need to talk to your lawyer about those possibilities of, first of all, the drawbacks, but if you are a person that could potentially get away with this, it's something you got to talk about with your lawyer first. So I'm cognizant of how much time we have left. We're getting up to the 1 hour mark here. I've talked about already how anything with a named beneficiary will pass outside of the estate. These are some examples of some of the plans that I mentioned. Segregated funds is also considered an insurance policy, and therefore you can name a beneficiary, it can pass outside of the state probate tax. How you achieve these beneficiary designations, though, there's a few different ways to go about it. One is using the forms that the institution you hold that plan with or policy with, which can give you to fill out. Easy to fill those out, allows for probate tax savings, but it doesn't allow for gift over planning. If you use those forms, it's basically, you know, first beneficiary is my spouse, alternate is my kids, 50-50 if there's 2 kids, for example. If one of those kids free to see says you don't update your beneficiary designations, everything's going to go to the surviving kid. For a lot of parents, a lot of situations, that may not be the intention. Most of the time where there is a child that then has kids of their own, they would want it to pass down the line of descent rather than everything going to the surviving child. You can't achieve that on a beneficiary designation form. That's something that you should be talking to your estate lawyer about, either leaving the estate, paying the probate tax, or having registered plan trusts, life insurance trusts that both save the probate tax, but also allow for more complex gift over planning and trust planning that we've already talked about. Because again, those forms too, you can't name a minor child on those forms, because then there's nothing setting out who can actually manage those funds for that minor child if they were to actually become entitled to those funds prior to being 18. Not to mention, they would get all the funds at age 18 if they're just named on the form. So we don't want to do that. How you achieve your beneficiary designations to reflect your intentions is something else you need to speak to your estate planning lawyer about, the long and short of it, basically. Joint partner, alter ego trust. These I'm not going to get into too much detail about, because I did mention I'm only covering some trust basics, but these are trusts that are available to clients who are 65 years of age or older. We'll do the last poll right now that we have a couple of minutes left, and then after that poll, I'll wrap things up. So this one is, which of the following are reasons why one may want to establish a trust? Privacy, protection from creditors, probate tax planning, or all of the above? I think that's everyone. Okay, I've learned a lot from these questions. That all of the above are way too easy. Yes, it is all of the above. These are all good reasons why you would want or people consider trust planning. Sometimes it will be a family trust. That's another one that applies for a lot of business owners. It allows for some income splitting opportunities. It can maximize access to the lifetime capital gains exemption. So family trusts are a common one that I see with business owners, and oftentimes those may be done in the context of an estate freeze, which is also quite a complex estate planning strategy, but something that can be hugely useful to business owners that is very income tax driven. And one thing that I can, wrap things up on here is that the income tax considerations are always going to far outweigh the probate tax considerations. And so that is something that another reason why we don't want the probate tax planning to be basically leading the whole plan, because there's going to be other considerations such as income tax planning, with the income tax bill being a lot more than that 1.5% probate tax bill, that is going to outweigh letting the probate tax planning lead the whole plan. And so it has to be viewed very holistically. We need to look at the big picture to determine what that plan looks like. Saving probate tax for that 1.5% may not always be worth the cost it comes for some other piece of the plan. So I can wrap things up here. I guess that's a good way to wrap it up, in that there's so many moving parts in any given estate plan, and you want to make sure that all of those plans and how they work together, how they're integrated with one another, is factored in to your overall estate plan. And it's really something, again, that you need to speak to your estate planning lawyer about, to make sure that that reflects your intentions, but also that you're getting the relevant advice to see what would be recommended based on your particular situation. So I'll wrap it up there. I think an hour of estate planning is probably enough for everyone there. So thank you all. And I guess that there's some time left at the end here for questions.
So there are some questions for you, Megan. You answered a few of them as you were going through things. So some of them have been covered off, but one of the first questions was, can a beneficiary of someone's estate also be an executor of the estate?
Yes, absolutely. A lot of the time, the executor will be someone who's also a beneficiary of the estate. They don't necessarily have to be. And depending on the family dynamics, for example, someone may want an objective executor that is not one of the beneficiaries. For example, they may not want to name, if they have more than one child, they may not want to name just one of those children, or their kids may not get along and they don't want those kids to be the beneficiaries and the executors. But they feel that if they name one of the kids as an executor, that's going to create a problem with the other children. So there's a number of situations where it makes sense to have an objective executor. Sometimes that may be a trust company, or sometimes people will name a professional like a lawyer. I've seen people name an accountant, but someone objective, where they don't, for reasons like those examples, they don't necessarily want them to be the same person, but they definitely can be.
Okay. And I think the thing is that for complicated estates, if your beneficiaries are people who are not really prepared to take on a complicated estate, that's where a third party also comes in handy.
Oh yeah, that's definitely another great example of where you'd want a professional. Being an executor, I think a lot of people have come around to the reality of this, but it is not an honor. Maybe for some people it is an honor too, but I think less and less that's the case. People understand, or seem to understand a lot more often now, the people that I speak to in my line of work understand that this is a job, and it's a pretty thankless job at that. Yeah. You can get compensation for acting, but the amount of work involved, the amount of headache you may deal with, which can be a lot, it's really the long and short of it. It's a lot of work. And so more and more people, I think, are recognizing that it's not just an honor. It's definitely a very difficult and can be quite complicated job. And like you said, depending on the complexity of the estate, not everyone is really up to what that entails. So
Right.
Specific
And
property is huge.
I think it's nice until you actually get to do the work.
Yeah.
Okay, so I think you basically answered this question, but I'll read it out to you. Does probate apply to real estate assets owned jointly with siblings or parents?
So the default is that it can own, so only assets that are owned jointly with right of survivorship with a spouse get that treatment where they pass outside of the estate by default. They pass outside of the estate, not subject to probate. If you own real property with anyone else, a parent, a sibling, the default is that there's what's called a presumption of resulting trust, meaning that if it's that parent or sibling, there's that it gets more complicated, no doubt, where it's a parent or sibling, because then you have to look at, okay, but whose was it really? Because there hopefully will be some documentation to support that. Like in the case of a parent and adult child, where the parent just basically swaps their child on title, but that the parent is the one who's actually living in the house, and the one who's paid for everything regarding the house, and they just did this as a probate tax saving strategy. That presumption is going to then presume, no, that child was just holding that asset in trust for the parent's estate. It's still a probatable asset. When you get into having parents and siblings on title, then are the parents and siblings actually living in the house? Did they jointly contribute to the cost of this house? Is it an investment property for two siblings and they have documentation to back up that they want it to pass to the survivor of them? So it will depend in that situation. But you'd have to look at a number of factors to determine that. And if that is the intent, that needs to be properly documented, because jointly owned assets with anyone other than a spouse are a huge source of complications and fighting, basically, because people will argue over how it's supposed to be treated. And so it's very important that intentions are properly documented whenever any asset, real property, bank account, whatever, is owned jointly with anyone other than a spouse.
Thank you. Next question. Do you advise on cross-border estate planning for clients with real estate interests in Florida in the US?
I have a number of clients with assets outside of Ontario. I do not give them the advice on how to deal with that particular asset, say, for example, in Florida. I can't give them advice in Florida since I'm not licensed in Florida. But what will oftentimes happen is they'll have their lawyer in Florida draft their Florida documents. I draft their Ontario documents, and I work with their Florida lawyer to make sure that the documents work as a team, and that each set of documents only governs the assets that they're intended to in their respective jurisdictions. There's no contradiction. None of those documents are revoking each other. So I'm oftentimes working with lawyers in other jurisdictions to make sure that everything works cohesively as a team. I've had clients, specifically a number with assets in Florida, and every jurisdiction is going to have their own different planning strategies available to them. For example, I've had clients with real property in Florida who end up doing with their Florida lawyer. Their Florida lawyer drafts this, because this is a thing that exists in Florida that we don't have. They will draft what's called a ladybird deed for the real property in Florida, and then we deal with the other assets here accordingly. But they're working with their Florida lawyer to look at all the assets and determine how everything is going to fall into the plan. But that's just one example in Florida that comes to mind. And similarly, the primary secondary will structure that I mentioned, that's an Ontario thing. Other provinces don't allow that, nor do places in the US have primary and secondary wills. But so the Florida lawyer, just like I'm not drafting the ladybird deed, that Florida lawyer would never be drafting the primary and secondary will, because they don't have those there. So it's really important to have lawyers in the respective jurisdictions that can draft the requisite documents specific to that jurisdiction and give you the relevant advice based on where the asset's located and where your resident is going to play into that too. So it's going to be different for a resident of Ontario who has Florida assets versus I've been on the flip side of that too, where I have a US resident who has Ontario assets. And then again, I'm working with the lawyer there, but there's other factors depending on the residency as well.
Right, and each of the wills, the US and the Canadian one, state that this just covers the assets in Canada, and then and they recognize that there is a secondary will outside
Exactly.
of it.
Yeah, that's right.
Okay, next question. Is having a Henson Trust and a RDSP for a child on ODSP a good idea?
Absolutely. Yeah. So, I mean, we can't say anything, I suppose, like applies to every single fact scenario. There may be a case where, depending on the value of the estate that would be going to that beneficiary, if it's so much that they don't really need their ODSP benefits anymore, whereby the money in the trust is going to be enough for them. They're not worried about putting them offside for ODSP because there's more than enough money there. They don't need to really protect that. Then they may not want a Henson Trust because they might feel that they don't need to be that restrictive because the ODSP is not really needed. But for most beneficiaries, they really rely, unless there's like a huge amount of money there, they're going to want to maintain their ODSP eligibility. So the example I just mentioned is going to be the exception to the rule. But again, something you need to talk to your lawyer about. Okay, what does this look like for us and for the beneficiary that we're thinking of establishing this Henson Trust for? You do need to look at the big picture because it's not a one size fits all. But for a lot of circumstances, you're going to want a Henson Trust when there's a beneficiary who's receiving ODSP. At the very least, you need to have that conversation with your lawyer. And then the RDSP is just a great investment tool for disabled beneficiaries who qualify for the disability tax credit, because it's also somewhere that they can put assets that is not going to affect their asset or income ceiling for ODSP purposes. So for most people who are receiving ODSP, having an RDSP, and then for any funds, any inheritance that they're going to come into, having an inheritance or a Henson Trust for that inheritance is very important. They're both really great planning strategies. And whenever there's disabled beneficiaries, it's really important that proper planning is done. I've seen so many cases. Another example of where saving the probate tax really ended up being the worst case scenario that comes to mind in this example is where I saw someone on the administration side. They came to me, it was two brothers, and their mom had named both of them as 50% beneficiaries on all of her registered plans because she thought, oh, I'm going to see a probate tax this way. They're just going to get named as beneficiaries on everything. Well, one of those brothers was on ODSP and he very heavily relied on his ODSP. So this was a huge problem because now he's getting that money paid outright to him. It's not in trust. He's just a named beneficiary. He gets his 50% outright. And so that is a huge problem. That mom thought she was doing the right thing by saving the probate tax, but in fact, she put her son in a really difficult situation by now him being ineligible for his ODSP. There's some things we can try and do where the proper planning is not done. We have some mechanisms available to try and fix that. For example, something called a disability expense trust. Lots of limitations there. You can only put up to $100,000 in a disability expense trust after the fact. So that's just another example where probate tax planning ended up really messing up the overall plan. And so another takeaway for that, but also a takeaway that whenever there's a disabled beneficiary, anyone who's receiving ODSP, you got to make sure that you have a really good plan in place.
Absolutely. If you named an executor that is not able to execute by on their own, can the named executor get a firm to do the process on their behalf?
Oh, so yeah, so an executor, basically, if you name someone as an executor in your will, they do not have to take on the job. They can just renounce and say, yeah, I don't want to do this. They could do that. In which case it would be, depending on the facts, it'd be a question of who steps up, whether there's an alternate named in the document who has the first right to step up, or if no one wanted to step up, if a trust company were willing to take it on, which will depend on the size of the estate, whether they're willing to do that job. It's got to be worth it for them to get the fees that will make it worth it from the size of that estate. and just the general nature of that estate really will inform that, the facts of it. And so there may be an opportunity for that, depending on the facts. There's also the opportunity for executors to hire a trust company, say, as an agent who helps them. Even though the trust company is not officially an executor, they're the agent of the executor and is helping them with a lot of the legwork. Or they don't even have to go so far as to name an agent in some cases. They may sometimes just getting the advice of the lawyer, the accountant will be enough for some executors, but it depends on the circumstances, whether or not that will be. And particularly in complex cases, it may make sense at the very least for them to have a trust company who's hired as agent if they don't just wash their hands all of it all together. But that is an option for every executor.
Right. And typically there's always more than one executor that's appointed in the will. And it's a good idea to talk to the executors ahead of time to make sure that they're on board with actually taking on the responsibility.
Yeah, absolutely. You should talk to them in advance, because if you name someone and then when you pass, it's like, surprise, you're the executor and they have no interest in doing that job. It's kind of a waste of a slot in your will, because you want to name someone who ideally you think will actually want to take on or would be willing to. And of course, circumstances change. Maybe at the time you do your will, they are the perfect person to name. And by the time you die, they're in a situation in their life where it's just not feasible for them at that moment. Of course, there's only so much, you can plan for and try and speculate, but ideally you're at the naming people who you expect would be willing to take that on, and that from having that conversation with them.
Absolutely. So this question has come up a couple of times. Can my power of attorney and my estate executor be the same person?
Yes, definitely. And oftentimes they are, not always, but oftentimes they will be the same person.
Right. Can you provide a referral for a law firm in Florida that you work with to advise on cross-border real estate? So I'm sure they can get in touch with you. And
I could provide the information for the lawyer that I worked with on the Lady Bird deed, for example. If someone wants to reach out to me, then I can definitely dig that up.
Okay, and then this one is kind of a little bit more complicated. How, and I think you've addressed it, how is adding kids on the will bad? And I don't think you said that adding kids to the will is bad.
Oh, right? The question was, how is it bad?
Yeah, how is adding kids on the will bad?
It's not bad. No, it's not bad to name. Most people do name their kids in their will. So there's nothing bad about naming your kids in your will at all. It's just it gets complicated when you slap your kids' names on title to your real property or any of these things. You want to make sure, however you want your assets to get to your kids, whether it's through the beneficiary designation, through your will, we want to make sure that it's just, we're talking about how it can be done best, whether through making sure that we have the correct type of trust in place, as the case may be. So most people do name their kids in their will. That's the exception that they don't. Although one thing I will say is that depending on the age of your kids, you may not want to actually name your kids by their name in your will. Where I have clients who are still maybe having more kids, then they won't name them. They'll say, to my issue in equal shares per stirpes, because that term will cover any children that they have at the time of their death, because they don't necessarily want to have to update their will if they're expecting to have another kid a couple of years from now or planning to. So depending on the number of kids there are, and if they're the client's planning on having more kids, we might word it differently, but it's the same result, is that most people want their kids to be beneficiaries of their estate and have in their will one way or the other.
So I'm going to do one more question and then we'll wrap it up. So the corporate executor has come up. You've discussed it a little bit already and where it might be suitable, but can you speak a little bit to what the cost of using a corporate executor is?
So the fees there are usually the main reason. Like that's really the one of the only downsides, I would say, and usually the main one, is just that there's a cost that comes with that. Like, they're in the business of doing this, right? So you're going to have to pay for it, or
Absolutely.
your estate is going to have to.
And you're
Most
looking for their expertise, so.
Well, that's just the thing. And I was just gonna, okay, sorry. I'm seeing if I can unshare that, but if that's distracting to still have my screen up. But in any event, as far as the fees go, usually they will have a sliding scale of how their fees are charged. So they might say on the first $1 million of your estate, we're going to charge 4.5%. On the next $1 million, we're going to charge 4%. It will depend on the trust company that you're dealing with, what their exact fees are. There'll be typically some type of discount for any fee or for any asset that they actually already have under their administration.
Right.
They'll usually provide a discount for that. They're not charging on any assets that pass outside of your state and don't have to pass through their hands at all, for example, because they pass by beneficiary designation instead. So there's some, caveats to exactly the assets that are getting factored into the compensation. But like you said, the cost of their fees, or as you've alluded to, like, can certainly outweigh the cost of having someone who's not appropriate in that job, because they are in the business of doing this work. They know how it's done. You can trust that they're going to do a good job. And they have also that advantage of being objective in those situations where you don't want to say name one of just the 3 kids, because it's going to create conflict where your kids just don't get along, for example. But there's tons of other examples where maybe the complexity of the estate, the size of the estate really informs just having a trust company involved. But really it's only the fees. And I would say in some cases, like the fact that they don't necessarily have they don't have the same personal relationship with that person. And so sometimes I'll see where they'll name a family member or friend to act as co-executor with the trust company, because they want the expertise of the trust company. They understand the fees that will be entailed. They also want someone who knows them personally to be able to weigh in on certain decisions from the personal side of things. And so that can be a good alternative to combating the fact that if you do name a trust company, you have this corporation acting as your executor that doesn't have the same insight into what some of your personal preferences might have been.
Yeah. So last thing here is, will this presentation be available later on? The recording of this whole presentation will be available shortly on the TMFD website. So we will go into that. But first, I'd like to thank you, Meghan, for joining us this evening. It was great information and some excellent points for people to ponder over before hopefully they call you and get working on their wills.
My pleasure. Thank you so much for having me. And yeah, if anyone has any follow-up questions that they want to reach out to me on, I'm happy to answer those and speak more to anyone about their estate planning. So I appreciate everyone's time tonight and for you having me here and inviting me.
Thank you everyone for joining us this evening. A reminder that PACE credits will be issued within the next 2 weeks. And we'll hope you join us again for our next presentation featuring Dr. Lionel Lenkinski, who's a practicing orthodontist and also CEO of the Canadian Dental Protective Association. He will be discussing risk managing your practice. This is scheduled for Wednesday, November 27th at 7 p.m. And you can register on the TMFD website under the Academy page. And again, thank you, Meghan, and thank you, Aaron, for running the show. And thank you to the guests. Have a lovely evening.